it wouldn't be peanut butter. If I were the defendant, I would argue that the advantages of letting an occasional peanut get into the peanut butter outweigh the disadvantages, because it would be almost impossible to prevent it from happening, and so the advantage of letting it get in once in a while is that it makes peanut butter available to the public. If I were the plaintiff, I think I'd be hard-pressed to come up with an argument. But if you paid me enough, I'd probably say that when somebody chokes on a peanut, a life may be lost, and there is nothing in this world more valuable than a human life. So even if it would have doubled the price of peanut butter to keep the peanuts out, the advantage of doing so would have outweighed the disadvantage of spending the extra money. Incidentally, I told you before that California, which invented this concept, really is in a minority. There are some jurisdictions which agree with California, and what they've kind of done was said the product is defective if the reasonable consumer would have expected more, or if the product is unreasonably dangerous. In other words, instead of requiring both defective and unreasonably dangerous, the minority of jurisdictions require either or. Don't forget that in a products liability case, as in any other tort case, it's going to be necessary for the plaintiff to show proximate cause and damage. Don't forget the possibility of defenses. Remember that in the majority of jurisdictions, contributory or comparative negligence are defenses that can be raised in negligence cases, but not in strict liability cases, not in warranty cases. Remember that assumption of the risk can be raised as a defense to all of the three approaches: negligence, warranty, and strict liability. And remember also that in a minority of jurisdictions, contributory or comparative negligence can be raised as a defense to all three theories. Products liability. All right, let's talk about a family of torts known as defamation. There are two torts in this family. One is called libel. The other is called slander. I find this interesting. In ancient England, libel and slander were crimes. Libel was a felony, which means it was punishable by death. Slander was only a misdemeanor, which means it was punishable by a short prison term. Nowadays, libel and slander aren't crimes. They're both varieties of the family of torts known as defamation. There's still a bit of a difference between them, but not nearly as much of a difference as there used to be. We're going to define them both in terms of the same set of essential elements, and we'll distinguish between them when we come to the element of publication. So, the torts in the defamation family can be defined in terms of these essential elements. First, a defamatory statement about the plaintiff. Second, falsity. The statement must be false. Third, fault is usually required. We'll talk about that. Fourth, publication of the statement. And fifth, damage. Let's take these elements one at a time. The first element is a defamatory statement about the plaintiff. A defamatory statement is a statement that's usually associated with shame or disgrace. The way I like to remember it is by thinking of that Paul Simon song that goes, "Her mama looks down and spits on the ground every time my name gets mentioned." Well, if a statement is defamatory, that means it's the kind of statement that would cause people to spit on the ground in disgust when they hear it. A statement associated with shame or disgrace. But there's a little bit of a problem with that definition, because no matter what you say, you can always find somebody that'll spit on the ground when they hear it. You know, there's some people that hate lawyers. So if you say, "Hey, Finns is a really good lawyer," they'll spit on the ground. They'll say, "That's disgusting. I hate lawyers." So when we say that a statement is defamatory, if it would cause people to spit on the ground, and by the way, don't write that in your exam booklets. Your professor might not be familiar with that little definition of mine. When we say that a statement is defamatory, if it would tend to hold the plaintiff up to shame or disgrace, we're talking about holding the plaintiff up to shame or disgrace in the eyes of people whose philosophy is respectable and not antisocial. So if you say that, well, there are 10 million or 10,000 mafiosi in the United States that just hate police. So if you say John is a cop, those people will think it's shameful or disgraceful. That doesn't make the statement John is a cop defamatory, because the people who would spit on the ground when they hear that statement are doing so out of an antisocial philosophy. It's not a respectable philosophy that's driving them to do that. So, if you publish a false statement in the paper that said, John helped the police to catch a notorious criminal, and maybe John has a lot of friends among the underworld, and his friends stop talking to him when they read about that. Maybe even it costs John a loss of business because he does a lot of business with his friends in the underworld. Nevertheless, the statement is not defamatory because it would not cause respectable people to think of John in terms of shame or disgrace. There are two ways that a statement can be defamatory. One way is on its face. That means the statement itself contains all the information you need to know that there's something shameful or disgraceful about John, about the person regarding whom the statement was made. So if I say, yesterday the Koh-i-Noor diamond was stolen from Lady Diana's crown, and John is the one that stole it, I have made a statement which is defamatory on its face. But a statement can also be defamatory by innuendo, and I want to warn you, that has a different meaning in the law than it has in the English language. In the English language, innuendo means you hint at something without actually coming out and saying it. But in the law of defamation, when we say that something is defamatory by innuendo, that means that the statement alone is not enough to associate John with shame or disgrace, but there exists a fact, not mentioned in the statement, which, when coupled with the statement, would associate John with shame or disgrace. Suppose, for example, that the diamond, the Koh-i-Noor diamond, was stolen from Lady Diana's crown yesterday. And suppose that I said, do you know that John acquired the Koh-i-Noor diamond? Now, there's nothing shameful or disgraceful about acquiring a valuable diamond. But if you couple my statement with the fact that the Koh-i-Noor diamond was stolen yesterday, it creates an innuendo, which says, in effect, that John stole the diamond, or that he was involved with the thieves. That's defamation by innuendo. File that in the back of your mind. We're going to come back to that in a couple of minutes. The first element is a defamatory statement about plaintiff. We know what a defamatory statement is. What do we mean when we say a statement about plaintiff? Well, obviously, if I name the plaintiff in the statement, if I say John Smith stole the Koh-i-Noor diamond yesterday, I've made a statement about the plaintiff, John Smith. But it may also be a statement about John Smith if I describe him in a way that would lead the ordinary person who knows him to recognize him. If I said, the Koh-i-Noor diamond was stolen yesterday by a tall guy who likes to wear green hats with feathers in them and a shirt that says on it, I am cool, and he also has a blonde mustache, one brown eye, one blue eye, and he wears glasses with purple frames. If that description that I have given would lead the ordinary person who happens to know John to recognize John, then I have made a statement about John. Now, please understand, when I talk about the ordinary person who knows John, I'm not talking about a real person. I'm saying imagine that there is somewhere an ordinary person who knows John. Would that person recognize John from the statement? If so, the statement is about John. Perhaps you read a case about somebody who wrote a book called Touching, in which she described, it was a novel, in which she described a person who engaged in marathon encounter therapy. And there was a man who actually did engage in marathon encounter therapy, and he said, hey, that book was about me, and it tells a lot of lies about me. And the writer of the book says the book was not about you. The book was about a fictitious character. The court in that case said, if the ordinary person who knew this plaintiff would think the book was about this plaintiff, then the book makes statements about this plaintiff. I think if you read that case again in view of this rule we've just discussed, it'll make maybe more sense to you than it did the first time around. The second element, falsity. because no matter how defamatory the statement is, if it's true,